Okay, let's unpack this. If you've ever poured your energy into developing, a truly novel idea for an invention,
Hmm.
you've likely hit that point where you wonder, how do I actually protect this?
Right. The big question.
And one of the most common questions, maybe even a bit of a head scratcher, is whether you actually need to build a physical working prototype, like a tangible model,
Yeah.
before you can even think about applying for a patent. It sort of feels intuitive that you would, doesn't it?
It really does.
Yeah.
That's a very common assumption.
Well, this deep dive, we're going to cut straight to the answer, pulling directly from the source material you shared, focusing just on the specific question.
And it's a fundamental question for inventors, absolutely.
Yeah.
Surrounded by, well, a lot of assumptions, like you said.
Yeah.
Many people just believe that without something physical to show, your idea is just, well, an idea. Maybe not ready for formal protection.
Right, just floating out there.
But the source material we've got here, it offers a very clear and maybe for some a surprising perspective on this.
Okay, so let's get to it. The core insight, right there in the source, it seems pretty unambiguous.
It is.
Can you patent an idea without a prototype? The answer, simply put, is yes.
Yes, exactly. The source material clarifies that a physical model is just not a prerequisite for filing a patent application.
Okay.
It tackles that misconception head on, the one about needing to physically demonstrate the invention right at the application stage.
So if you don't need the prototype, what does the source say you need? I mean, how do you bridge that gap between an abstract concept and something protectable?
That's where the source gives us the crucial detail. Instead of that physical model,
Yeah.
the requirement is a really comprehensive and clear written description of the invention, right there in the patent application itself.
Okay, so the paper is the prototype in a way. Is that fair?
That's a good way to think about it. Precisely. The source emphasizes that the written description, maybe with detailed drawings if they apply,
Right.
must be sufficiently clear and complete. Enough to enable someone who's, skilled in that particular field
Okay.
to actually make and use the invention, and without needing, excessive experimentation.
So it's really about fully disclosing how it works, structure, function.
Exactly how it operates.
That makes sense. Because the whole point of the patent is teaching others about your invention in return for that exclusivity period. So the description has to do the teaching.
That's it.
What key parts of that description does the source really highlight?
Well, the source material points to a few critical things. First, there's that detailed written description we just mentioned, often called the specification.
Specification, got it.
But just as important are the claims.
The claims.
The claims are, you could say, like the legal boundaries of your invention. They define precisely what you're seeking to protect.
Okay, so they fence off your territory.
Exactly. And the source explains these claims have to be fully supported by that written description. And they also need to be clear and definite. No ambiguity.
So you need the big explanation, the drawings maybe to show it, and then the claims to really nail down what the patent actually covers.
Got it. And the source material is quite firm on this point. It actually uses the specific phrase, no model required.
Oh, interesting. Explicit.
Yeah, to really underscore that this comprehensive written and illustrated disclosure is what counts for the application, not a physical thing.
So the law protects the idea as described.
The inventive concept, yes, and how it's reduced to practice in writing in the application. That description is the proof of concept for the application process itself.
Got it. Okay, so let's recap the main takeaway here from your source material. You absolutely can patent an idea without building a physical prototype.
Correct.
The critical requirement, which the source makes really clear, is providing that detailed enabling description in the application, specification, drawings, clear claims.
And as we noted, the source explicitly says, no model required.
No model required. Simple as that.
And this brings us to a fascinating point for you, the listener, to maybe mull over, building just on what we've discussed from the source.
Okay.
If that's standard for getting a patent, when you don't have a prototype, rests entirely on providing a description so clear that someone skilled in the field can make and use the invention.
Right. The enabling description.
What does enabling truly mean in practice? How much detail is actually enough detail to meet that standard? Enough to stand up to scrutiny, just based on words and drawings alone, without ever needing a physical model to prove the point later?
That's a good question.
It really highlights that tricky challenge, doesn't it? Translating a potentially complex idea into a legal document that has to stand entirely on, well, the power of how it's articulated.